Excellency, dear colleagues, ladies and gentlemen, I welcome you to this high-level video conference on the use of modern technologies and the violation of international humanitarian law and human rights in Western Sahara. First of all, we will hear an introductory remarks of His Excellency Dr. Naledi Pandor, Minister of International Relations and Cooperation of the Republic of South Africa. Unfortunately, we cannot share the video, which will be shared later on the social media, but we just will listen to her. Please, Omeima.
To deliver opening remarks today. We are honored that the Geneva Support Group for Western Sahara has once more asked South Africa to chair the group for the second time since its establishment in 2016. I'm sure that you're all aware that our government and the people of South Africa stand resolutely in support of the freedom struggle of the Saharawi people and their right to self-determination. The long-standing illegal occupation and annexation of the majority of the territory of Western Sahara has been condemned by both the UN Security Council and the UN General Assembly. In 1975, the International Court of Justice ruled that there is no legal tie of territorial sovereignty between the territory of Western Sahara and the Kingdom of Morocco. The court did not find legal ties of such a nature as might affect the application of Resolution 1514 in the decolonization of Western Sahara, and in particular of the principle of self-determination through the free and genuine expression of the will of the peoples of the territory. The long-standing illegal occupation and annexation not only violates the principles and purposes of the UN Charter, but it constitutes a dangerous attempt to the breach of the fundamental principles of the Constitutive Act of the African Union, in particular its objectives listed in Article 3 and its principles enshrined in Article 4. Our government deeply regrets the resumption of the armed conflict in Western Sahara. South Africa welcomes the appointment by the UN Secretary General of Ambassador Staffan de Mistura as his new personal envoy for Western Sahara. And we hope and trust that he sees the urgency in working toward a final conclusion of this long-standing illegal occupation and annexation. The resumption of the armed conflict in Western Sahara has seen the use of the most sophisticated modern technologies in that conflict. These modern technologies undoubtedly contribute to the continuing serious breaches of the international humanitarian law and violations of the fundamental human rights of the Sahrawi people in Western Sahara. It is against this background that we look forward to the valuable contributions from the panelists who will seek to shed light on these violations, both from the perspective of international law, as well as that of the victims on the ground and abroad. It's my pleasure, therefore, to give the floor to the moderator of the conference, Mr. Fattorini. I wish you all an instructive and fruitful session, and I thank you all for your kind attention.
I thank you, Mr. Pandor, for her message. And I should also stress that South Africa is also leading this year the Geneva Support Group for Western Sahara. So my thanks goes to Ambassador Nkosi and all his colleagues in the South African Permanent Mission. The issue of the use of modern technologies and its implication is currently under consideration by several mechanisms of the UN human rights system. In March 2014, at its 25th session, the Human Rights Council adopted Resolution 25/22, which dealt with the respect of international law, including international human rights and humanitarian law, when using remotely piloted aircraft or armed drones. The Council invited the UN High Commissioner for Human Rights and relevant special procedures of the Human Rights Council and the human rights treaty bodies to pay attention to violations of international law as a result of the use of remotely piloted aircraft or armed drones. In March 2015, at its 28th session, in adopting Resolution 28/3, the Council renewed the invitation to the UN human rights machinery to pay attention to violations of international law as a result of the use of remotely piloted aircraft or armed drones. Both resolutions were adopted by a recorded vote, and interestingly, the Kingdom of Morocco, which was member of the Council at that time, voted in favor of both resolutions. In recent years, the Human Rights Council and the General Assembly held several debates on the implication of the use of communication technologies and communication surveillance. In his call to action for human rights, the UN Secretary General called for member states to place human rights at the center of regulatory frameworks and legislation on development and use of digital technologies. In 2013, already, the Special Rapporteur on the right to freedom of opinion and expression stressed that states should be completely transparent about the use of scope of communication surveillance techniques and powers, and that states should establish independent oversight mechanisms capable to ensure transparency and accountability of state surveillance of communications. In his 2017 report to the Human Rights Council, the Special Rapporteur on the right to privacy recommended that states prepare themselves to ensure that both domestically and internationally, privacy is respected as a truly universal right. In its last report, the Advisory Committee of the Human Rights Council noted that all too often surveillance is conducted without appropriate safeguards, which impinges unreasonably on the privacy and reputation of innocent people and harms the democratic norms of society. Today, we will focus on the use of modern technologies by the Kingdom of Morocco in the framework of the armed conflict in the occupied Western Sahara that resumed on 13 November 2020. In December 2020, the Kingdom of Morocco has signed an agreement with Israel for the normalization of their diplomatic relationship. In November 2021, they signed a memorandum of understanding strengthening the cooperation on security issues. The Kingdom of Morocco has already bought unarmed drones carrying 20 kilos of explosive to Israel aerospace industries for $22 million US, as well as Israeli counter-drone system Skylock Dome. Meanwhile, the Kingdom of Morocco has also bought about 20 Turkish-made Bayraktar TB2 drones with a budget of about $100 million US. As of today, 80 civilians of different nationalities, including a child, have been killed in the territory of Western Sahara controlled by the Polisario Front, east of the separation wall. Six other persons have been injured. In July 2021, media and NGO sources disclosed a large-scale surveillance of cell phones by the Kingdom of Morocco through a surveillance technology provided by the Israeli private company Pegasus. Hundreds of Moroccan, Sahrawi, and foreign politicians, civil servants, journalists, and prominent NGOs members have presumably been and still are today victims of Moroccan state hacking activities. And with this, we will now listen to a video message of Honorable Yvonne Duzap, Minister of Justice of the Republic of Namibia. Here also the video will then be shared on social media. Omeima, if you are ready.
Moderator, Excellencies, distinguished participants, ladies and gentlemen, I feel extremely honored to provide a short message to today's webinar session dedicated to, and I quote, the use of modern technologies and the violation of international humanitarian law and human rights in Western Sahara, end of quote. Namibia, as a staunch supporter of the right of the people of Western Sahara to self-determination, is extremely concerned about reports of the use of drones by Morocco in its illegal military operations in Western Sahara, which has resulted in the death of Sahrawi civilians. The lack of accountability for present and past violations of international human rights and humanitarian law is clearly emboldening the occupying power Morocco to intensify its aggression against the people of Western Sahara. Namibia condemns in the strongest terms the attacks against the Sahrawi people, and we call on the international community to hold Morocco accountable for the repeated violations of international human rights and humanitarian law. We also wish to remind fellow states that the international transfer of arms, including modern weapons such as military drones and other lethal autonomous weapons, should be guided by international law broadly. States who transfer arms and modern military technology to conflict zones should know that they are contributing to the problem, as these weapons and technologies are most likely to be used by states such as Morocco to violate international human rights and humanitarian law. This does not contribute to the efforts of the international community to resolve the conflict, and it delays the realization of the long overdue right of the people of Western Sahara to self-determination. Namibia believes that the exercise of this right by the Sahrawi people is the only credible solution for sustainable peace in Western Sahara. Thus, while welcoming the appointment of His Excellency Alexander Ivanko as the Special Representative of the Secretary General for Western Sahara, we wish to emphasize that the UN efforts in Western Sahara should uphold the wishes of the people of Western Sahara. The right to self-determination belongs to the people of Western Sahara, and they should decide the future status of Western Sahara. Any attempt to impose a solution which is not accepted by the Polisario Front, the legitimate representatives of the people of Western Sahara, would seriously impair their right to self-determination. In conclusion, I would like to wish all the participants fruitful deliberations. We should never give up on our brothers and sisters from Western Sahara, because experience has taught us time and again that through international solidarity and relentless action, it is possible to ensure that peoples living under illegal foreign occupation realize their right to self-determination. Namibia will certainly not relent, and I therefore use this opportunity to reaffirm on behalf of the Republic of Namibia, once again, our unequivocal and unwavering commitment for the cause of the people of Western Sahara to attain their right to self-determination and national independence. I thank you, moderator.
I thank you, Honorable Minister of Justice of the Republic of Namibia, for the support message. reminding also the principle of international law. And now we will listen to two testimony of victims, either of the use of drones or use of Pegasus system by the Kingdom of Morocco. So first of all, I will give the floor to Mr. Hamdi Salek from the Sahrawi Association of Mines Victim, Azavim. Please, you have the floor. Hamdi Salek?
He's here, just a moment. Hamdi Salek, قلع الميكرو.
Peut-être en attendant qu'il résout son problème technique, je peux passer la parole à Madame Claude Mangin. Claude Mangin est l'épouse de Nam Asfari, prisonnier politique bien connu par la communauté internationale. Il a été reconnu en 2016 victime de torture par le Comité contre la torture des Nations Unies. Claude, tu as la parole. Micro, Claude. Micro.
Bonjour à tous. Donc, je vais vous parler de l'affaire Pegasus, en tout cas en ce qui me concerne. Donc, le 18 juillet 2021, une enquête journalistique coordonnée par le consortium de journalistes Forbidden Stories avec l'appui technique d'Amnesty International révélait l'existence d'une vaste opération de surveillance ciblée visant des milliers de journalistes, avocats, militants et responsables politiques. Cette enquête mettait à jour l'existence d'un logiciel espion, Pegasus, dont le but est de pénétrer dans des smartphones. Le logiciel est ensuite capable d'aspirer l'ensemble des données contenues dans un téléphone portable, photographies, carnet d'adresses, mots de passe. Surtout, Pegasus peut lire les emails, suivre les conversations téléphoniques, intercepter les messages, même ceux échangés sur les applications soi-disant sécurisées comme Signal ou WhatsApp. Le logiciel est enfin capable de géolocaliser l'appareil infecté, d'activer micro et caméra à distance pour transformer le smartphone en un véritable mouchard. Une fois le logiciel Pegasus installé sur un téléphone, il renvoie les données vers le commanditaire via un tunnel d'exfiltration des données. Exploitant des failles de sécurité des smartphones, le logiciel s'installe à distance, sans clic et sans que la personne n'en soit informée. Le logiciel Pegasus est commercialisé par la société israélienne NSO Group uniquement auprès d'États ou d'agences gouvernementales. L'enquête journalistique intitulée Projet Pegasus a eu accès à une liste de plus de 50 000 numéros de téléphone sélectionnés comme cible potentielle de Pegasus depuis 2016, pour le compte d'une dizaine d'États. En France, ce sont plus de 1000 personnes dont les téléphones ont été infectés. Le mien a été infecté par le logiciel Pegasus entre le 8 octobre 2020 et le 7 juillet 2021. Il y a eu 128 connexions entre ces deux dates. Il se trouve que la première connexion a eu lieu le 8 octobre 2020. Or, ce jour-là, j'ai eu un rendez-vous téléphonique avec Maître Breham, notre avocat Anama et moi. J'ai croisé mon agenda avec les dates de connexion indiquées sur leur relevé transmis par Amnesty et j'ai compris que c'est toute ma vie militante et privée qui a été surveillée entre ces deux dates. De nombreux événements me concernant ou concernant ma vie militante, pour lesquels je ne comprenais pas comment le Maroc pouvait en avoir été informé, se sont ainsi trouvés éclairés a posteriori. Maître Breham, Philippe Buissou, maire d'Ivry, notre ville de résidence, et Oubi Bouchraya, représentant du Front Polisario auprès de l'Union européenne et de l'Europe, et moi-même, avons ensemble porté plainte pour les infractions suivantes: atteinte à l'intimité de la vie privée, collecte de données à caractère personnel par un moyen frauduleux, déloyal ou illicite, association de malfaiteurs. Comme avocat, Maître Breham a vu le secret professionnel bafoué. Philippe Buissou, dépositaire d'une mission de service public, a été surveillé par un État étranger. La mise sur écoute d'Oubi Bouchraya a mis en danger l'ensemble des membres du Front Polisario. La surveillance de mes activités militantes pour pouvoir me rapprocher de mon époux a pu avoir des conséquences sur ma sécurité et celle de mes proches. Maître Breham a écrit dès le 21 juillet 2021 au Comité contre la torture pour dénoncer cette surveillance comme de nouvelles représailles contre moi et mon mari, alors que le comité, dans sa condamnation du Maroc pour fait de torture sur Namas Fari le 16 octobre 2016, a bien spécifié qu'aucune représaille ne devait être exercée contre lui ou sa famille. Les représailles contre moi sont nombreuses, comme celle de m'interdire l'accès au territoire marocain depuis 5 ans, parce que je suis un danger pour la sécurité intérieure et extérieure de l'État et pour l'ordre public. Suite à ce courrier de Maître Breham, le comité a écrit le 30 novembre 2021 au Maroc en lui demandant de répondre avant le 31 décembre 2021 sur la mise sur écoute de mon téléphone et de celui de notre avocat, car il constitue une violation de l'article 13 de la Convention contre la torture qui impose à tout État partie d'assurer la protection du plaignant et des témoins contre tout mauvais traitement ou toute intimidation en raison de la plainte déposée ou de toute disposition faite. Enfin, Vincent Ploton de ISHR, Service international pour les droits humains de Genève, a fait une communication auprès des procédures spéciales le 6 janvier 2022 concernant les liens entre ces infiltrations Pegasus sur mon téléphone et celui de Joseph Breham et les suspicions que celles-ci ont contribué au harcèlement dont a été victime Hassana Abba de la Ligue de protection des prisonniers politiques sahraouis en mai 2021 à l'Ayoun. L'agression avait déjà été reconnue par les procédures spéciales dans le courrier envoyé au Maroc le 10 juin 2021. Cette agression contre Hassana avait pour but de l'empêcher de documenter des nouvelles plaintes. Suite à la plainte déposée devant les tribunaux français, j'ai déjà été auditionné 2 fois par l'ANSSI, l'Agence nationale de la sécurité des systèmes numériques, agence qui est chargée par la police judiciaire d'enquêter sur Pegasus. Joseph Breham, Philippe Buissou ont aussi été auditionnés. Oubi Bouchraya doit l'être bientôt. Ils ont déjà auditionné une centaine de plaignants sur les 1000 personnes dont les téléphones ont été infectés en France. Ils ont aussi analysé mes téléphones. On peut dire que l'ONU, pour conclure, on peut dire que l'ONU et la justice française prennent très au sérieux ces dénonciations qui constituent autant de violations des droits de l'homme contre des militants. Je réaffirme que tout ceci n'aurait pas lieu si le premier des droits de l'homme, avoir un État pour le peuple sahraoui, n'était pas bafoué par le Maroc depuis 46 ans. Je vous remercie.
Merci beaucoup, Claude, pour ton témoignage. Maintenant, au Meima, je ne sais pas si Hamdi Salek est avec nous.
حمدي اللي قعدت معنا في ايدك حمدي السالك حمدي السالك اللي قعدت معنا في ايدك حمدي السالك نقلع الميكروفون وتكلم. On peut passer à la suivante parce que.
Well, yeah. I hope you will be able to join us.
No, yes, it seems. حمدي اقلع الميكروفون قلعته راك سلحته. ذاك المسيت راك.
Claude, tu peux fermer ton micro, peut-être.
اوكي ضريك تتكلم. خلاص تكلم ضريك.
بكار عمر احمد الاسم بكار عمر احمد.
We begin with بكار. تفضل تكلم.
بسم الله الرحمن الرحيم. الاسم بكار عمر أحمد، المزداد 1953. أنا بصفتي ندي بأعمال المغرب بالطائرات المسيرة استهدفت كثير من المواطنين في المناطق الثلاثة، في مهيريز والتفاريتي وبير الحلو، وهذه المشاهدة بالعين. استهدفت الخيم والحيوانات والمواطنين نفسهم، المدنيين نفسهم، وأنا كذلك تعرضت إلى نفس هذا الهجوم بالطائرات المسيرة، وكانوا من بين هذه الضحايا ولد لي قال له هيبة بكار عمر، صديقه سلامة وإبراهيم، بينما كانوا قائمين مهمة يجيبوا المواطنين في كوبا في منطقة مهيريز قرب من مركز المتحدة الموجود في المنطقة. هذا ما هو وحده، بل هناك ناس تعرضوا للطائرات المسيرة، حرقوا سياراتهم وحرقوا امتعتهم وحرقوا حيوانهم وامتلاكاتهم. ونندد بهذه الأعمال الشنيعة اللي يقوم بها المغرب، طائرات مسيرة للمواطنين ما يفهموها ولا يفهموا المنطق العسكري، بل هم عايشين منطقة محررة ولا هم عالمين بشيلين تخبطهم طائرة من ذا النوع اللي ما تقدر تشوفوها بالعين ولا يشوفها حد. ونكون احترامي هذه الطائرة اللي تحمل صواريخ موجهة دقيقة جدا وفتاكة، وفيها مادة حارقة تحرق وتخرق حق. وفي الأخير نكن احترامي للأجنة المشاركة كامل الاحترام وشكرا.
I apologize. The English interpreter was having his mic on or off, and just the person who spoke, he is one of the victims of the drones. محفوظ أعتقد تدير un petit résumé بالإنجليزية قدر دقيقة. Gianfranco, we are trying to make some resume in English because the interpreter was having his mic off.
نلعب
تتكلم دير رسومي دير رسومي على اوكي افكار لا قلنا انت منه وذا شنو لقى على كتوف العجله عله تكلم بكار
عمر. انا بكار عمر احمد، نندد بالاعمال اللي قام بها المغرب الطائرات المسيره ضد المدنيين، وكان هذه الطائرات تستهدفوا كوبا تحمل الماء يجيبوها للمواطنين، وكان من بين هذول الاشخاص ولدي صغير 25 سنه هو وصديق، ونحرق في هذه الكوبا اللي تجيب الماء للمواطنين. وشكرا.
سامعينك بعد سامعينك زين. خلاص Gianfranco, you can go ahead please.
Oui.
خلاص.
Juste pour comprendre, mais ça c'était son témoignage personnel ou il a résumé le témoignage de Hamdi?
Non, son témoignage personnel. Hamdi, je ne sais pas il est où. J'ai besoin qu'il se connecte.
D'accord.
Ok, après, oui. Après avoir, oui.
Okay. So we just listened to the testimony of Mr. Bakar Omar Ahmed, who is also member of the Sahrawi Association of Mines Victims, Azavin. And now I will give the floor to Mr. Abba Al-Hussein, who is President of the Sahrawi National Commission for Human Rights. Abba, you have the floor.
Merci beaucoup, cher ami Gianfranco. Je voudrais tout d'abord adresser mes sincères remerciements à tous ceux qui ont contribué de près ou de loin à la préparation et l'organisation de cette conférence importante. Je voudrais remercier le groupe de Genève d'avoir organisé cette précieuse conférence et de lui avoir choisi un titre très important qui reflète la réalité de la gravité de la situation actuelle concernant l'agression militaire marocaine contre le peuple sahraoui. Je remercie également et apprécie la présence des personnalités éminentes et nobles à cet événement. Chers amis, en ce qui concerne le sujet de la conférence, je voudrais aborder certains points que les orateurs aborderont avec plus de détails et plus d'expérience que moi, y compris ceux qui ont fait l'objet de cette surveillance et de cette pénétration d'espionnage de le soi-disant scandale Pegasus. Des responsables sahraouis, des militants des droits de l'homme et des avocats exerçant en France ont connu pour le soutien à la cause sahraoui ont été espionnés par le Maroc à l'aide d'un logiciel israélien depuis quelques années et ces agissements se sont intensifiés depuis la rupture du cessez-le-feu en novembre 2020, comme l'a révélé l'enquête de Forbidden Story et ses partenaires. En juillet 2021, des médias et des ONG ont révélé une surveillance à grande échelle des téléphones portables par le Royaume du Maroc grâce à une technologie de surveillance fournie par la société privée israélienne Pegasus. Pegasus suscite une vague d'indignation dans le monde. Mais nous, les Sahraouis, nous ne sommes pas surpris. Voilà des décennies que le Maroc viole la légalité internationale. Pegasus, tout simplement, c'est l'aspect le plus soft de l'occupation illégale que nous subissons. Même ceux qui soutiennent le régime marocain dans son aventure militaire. C'est le cas de la France et de l'Espagne, notamment sont espionnés. Aujourd'hui, le Maroc doute de tout le monde, de ses voisins, de ses alliés, de ses amis, qui depuis des années bloquent au Conseil de sécurité la voie vers un véritable référendum d'autodétermination du peuple sahraoui. Le projet Pegasus montre à quel point le logiciel Pegasus est une arme de choix pour les gouvernements répressifs qui cherchent à réduire en silence les journalistes et les militants et pour écraser l'opposition, mettant ainsi l'innombrable vie en péril. Chers amis, la reprise de la guerre le 13 novembre 2020 entre le Polisario et l'occupant marocain suite aux violations flagrantes par Rabat de cessez-le-feu entre ces deux parties conclu en 1981 sous l'égide de l'ONU pour la tenue d'un référendum d'autodétermination, la communauté internationale a failli à faire valoir la primauté et la force du droit international. Une politique marocaine porteuse de menaces sur la paix et la sécurité sur les plans régional, continental et mondial que nul membre permanent au Conseil de sécurité ignore à leur tête la France, qui persiste à user de son veto contre toute perspective d'aller sur l'application effective de la légalité internationale au Sahara occidental. Les attaques marocaines via des drones contre les civils sahraouis et leurs biens dans les territoires libérés sont multiples depuis la cadence accélérée de la coopération militaire entre Rabat et Tel Aviv dès la reprise officielle de leurs relations bilatérales longtemps entretenues officiellement. L'usage des drones par l'armée marocaine vire au terrorisme d'État, des avions sans pilote ont de nouveau été utilisés contre des civils sahraouis dans les territoires libérés du Sahara occidental. Au cours de cette année, au cours de cette période, 19 civils sahraouis, dont un enfant, ont été assassinés par des bombardements de drones marocains. 6 autres ont été blessés et 15 voitures et 15 camions civils ont été détruits dans les zones libérées de la République sahraoui. Tout récemment, un citoyen sahraoui, le Habib Agrechi, a également été assassiné à la ville de Dakhla, occupée dans des circonstances mystérieuses. En outre, il est noté que la situation d'hostilité armée a été utilisée par le Maroc pour réprimer la vie quotidienne de la population sahraoui, en particulier la population nomade dans les zones libérées, et des événements enregistrés considérés comme des graves violations des droits internationaux humanitaires, tels que des frappes aériennes par les drones contre la population sahraoui civile, qui ont causé aussi des déplacements forcés de la population, la destruction des puits d'eau et des camions citernes destinés à la population nomade et résidant dans les territoires libérés. L'utilisation des drones dans les conflits armés s'est considérablement développée ces dernières années, ce qui soulève des préoccupations de plusieurs ordres, notamment humanitaires et juridiques. L'État du Maroc continue de s'emparer des terres des Sahraouis et des biens des citoyens dans les territoires occupés et de piller les ressources naturelles du Sahara occidental en impliquant des parties extérieures dans les desseins de l'occupation militaire marocaine. En outre, chers amis, au cours de cette année, il y a eu des violations systématiques des articles 27, 31, 32, 33, 49, 53, 76 de la 4e Convention de Genève relative à la protection des civils en temps de guerre. La souffrance des prisonniers politiques sahraouis a nettement augmenté récemment et par conséquent, leurs droits sont gravement touchés et particulièrement sont liés à la santé. Les prisonniers du groupe de Gdemizig, condamnés à de lourdes peines lors d'un procès militaire entaché d'irrégularités, sont dans un état lamentable et dramatique selon les témoignages de leurs familles et aussi les rapports rédigés par la Ligue sahraoui pour la protection des prisonniers politiques. Ce cri d'alerte est également souligné par les familles des prisonniers elles-mêmes, qui lancent à travers les réseaux sociaux des appels à la conscience pour que la communauté internationale vienne en aide à ces prisonniers qui ne bénéficient d'aucune prise en charge médicale malgré leur souffrance ajoutée aux maladies chroniques dont ils souffrent suite au mauvais traitement, aux conditions inhumaines de détention et de leur privation de minimum d'hygiène. Au cours de l'année écoulée, plusieurs épisodes graves et particulièrement inquiétants ont été enregistrés concernant l'utilisation de la violence sexuelle comme arme de répression par des fonctionnaires marocains. Ces actes constituaient une violation grave des droits des femmes au titre de la Convention sur les femmes et de la recommandation générale 30 applicable au contexte des conflits et d'occupation. L'agression sexuelle de la militante Sultana Khaya et le viol à sa sœur Louara Khaya, survenus aux premières heures du 12 mai 2021, sont particulièrement flagrantes. La situation explosive au Sahara occidental pouvait ne pas avoir lieu si le Conseil de sécurité, à travers la mission La MINURSO, n'est pas manqué à son devoir d'empêcher la violation du cessez-le-feu par le Maroc, ce qui a contraint l'armée sahraoui à intervenir pour déjouer une tentative marocaine de se saisir de nouvelles terres et modifier la situation sur le terrain, en contradiction avec l'accord militaire numéro 1 qui fixe la relation entre la MINURSO et les parties au conflit. Chers amis, le Conseil de sécurité est responsable de l'impasse qui caractérise le conflit aujourd'hui, qu'il a accepté malheureusement que la MINURSO soit une exception qui se plie à la volonté de la force de l'occupation militaire illégale marocaine, de sorte que cette composante onisienne n'a pas la compétence des autres missions de maintien de la paix au niveau des normes et procédures en matière de la surveillance des droits de l'homme. Le Conseil des droits de l'homme des Nations Unies à Genève doit se conformer à la demande qui lui a été faite par l'Assemblée générale dans la résolution intitulée « Réalisation universelle des droits des peuples à disposer d'eux-mêmes » et à accorder une attention particulière aux violations des droits de l'homme, notamment des droits à l'autodétermination, et à envisager la création d'un mandat de rapporteur spécial sur la situation au Sahara occidental occupé. Le Haut-Commissariat aux droits de l'homme doit mettre en œuvre les engagements pris lors du sommet humanitaire mondial à Istanbul au mois de mai 2016 en ce qui concerne la situation au Sahara occidental, en particulier pour dénoncer et condamner systématiquement les violations graves des droits internationaux humanitaires et les violations et abus graves des droits internationaux des droits de l'homme. Le CCR doit être autorisé à visiter les prisonniers politiques sahraouis dans les prisons marocains et à assister les personnes protégées conformément aux dispositions pertinentes de la 4e Convention de Genève de 1949. Je vous remercie.
I thank you, Balesen, for detailed presentation, and I wish him all the best for the important work done by the National Human Rights Commission, Western Sahara National Commission for Human Rights. And I know he has to leave us because he is going to meet His Excellency Tsenene Simbone, Ambassador of Botswana to the Sahrawi Republic, who presented his credentials to the President of the Sahrawi Republic just yesterday. So thank you very much, Abba. And now I will give the floor to Mrs. Yulia Mogutov. Yulia Mogutov is a teaching assistant at the Geneva Academy of Humanitarian Law and Human Rights, and a PhD candidate at the Law Faculty, University of Geneva. Her research focuses on the management of natural resources in armed conflicts. Before joining the Geneva Academy, Julia has been working as a legal advisor with the regional delegation of the International Committee of the Red Cross for the Russian Federation, Belarus, and Moldova. Among other projects, she was involved in international humanitarian law dissemination and working with academic cycles and think tanks, as well as on international humanitarian law implementation at the national level. Yulia holds a LLM in international humanitarian law and human rights from the Geneva Academy and a specialist degree in law from Kutafin Moscow State Law University with a specialization in international energy law. Please, Mrs. Mogutova, you have the floor.
Good afternoon, and thank you very much. Your Excellencies, distinguished speakers, and the audience of this very important event. I would like first of all to thank Mr. Fattorini for his kind invitation to speak today about the legal framework of the use of drones from the IHL and human rights perspective. I have to say that it's always very difficult to speak about legal norms after the testimonies of victims and witnesses of those violations. But I would like to provide you with the key points of the legal framework that are relevant for today's discussion, and I hope that you will find this short introduction useful. When we're speaking about targeted killings conducted by drones, it is very important to define the context where the operation is taking place. The legality of the use of drones primarily depends on the legal framework that is applicable to the situation at issue. If the drones or other unmanned weapons are used within the context of the conduct of hostilities, which in other words during an active phase of an armed conflict, where the belligerents are turning to violence against each other. The assessment of legality has to be conducted from the perspective of IHL. So the norms that are regulating international armed conflicts or non-international armed conflicts. In our case, I will focus only on the international armed conflicts today, because that's the relevant legal framework for Western Sahara. At the same time, if the drone operations are being conducted far away from hostilities, in a different country or within the country where the conflict is taking place, but not in the battlefield. We know a lot of examples also from the past where one of the first drone operations took place in the so-called war on terror, where the states would conduct operations across the continents to target particular members of the targeted groups. The same situation can also appear outside of active phase of an armed conflict. For instance, during a phase of occupation, where the belligerents do not turn to violence, but the enemy state is controlling effectively the territory of the other state, or the territory that belongs to people that are fighting for self-determination. In this case, we have to have a closer look at the norms of international human rights law, because this framework will prevail. I will first turn on to the IHL perspective and the IHL framework to understand whether drone operations can be conducted in general, and when they can be seen as legal, and when there is a violation of humanitarian law. First of all, we need to understand whether drones as weapons are compatible with international humanitarian law. Every state is under obligation to determine whether the new weapons can comply with humanitarian law. So whether they can distinguish between civilians and combatants, whether they do not cause excessive harm, whether the damages that they cause will not have a long-lasting effect to environment, and there are many other conditions. This obligation comes from Article 36 of the additional protocol. Every state to this international treaty is under obligation to ensure that the new weapons are in compliance with IHL. And here is important that it's not only the state that is developing those weapons or producing it, but also the state that is acquiring them in order to use it in its all military operations. From the first sight, drones as such are not in violation of IHL, as long as they can distinguish between the targets, as long as they can target only military targets, such as military objectives or combatants, and as long as they do not cause superfluous injuries and unnecessary suffering to the victims. At the same time, it doesn't mean that every operation conducted by drones will be compatible with IHL. And any attack has to be analyzed through the following structure. Well, first of all, we need to understand what was the initial target of the attack. Attacks may be conducted only against military objects and combatants. In very exceptional situations, civilians can be targeted, but only during the time when they directly participate in hostilities, and only at the moment when they are actively engaged in those hostilities. In general, attacks against civilian population or indiscriminate attacks that do not distinguish between the targets are prohibited under IHL and can amount to war crimes and grave breaches of the Additional Protocol 1. Even if an attack is conducted against a legitimate military target, such as military vehicles or commanders or just combatants of the enemy army, such attacks have to be proportionate. The rule of proportionality is an assessment of the situation where a civilian damage is unavoidable. The commander, before launching an attack, is supposed to understand whether the whether the anticipated military advantage will not be excessive to the civilian damage that will appear out of such an attack. One can say that the problem is that the operator of the drone is somewhere far away. So the person cannot really understand and foresee the civilian damage or military advantage from such an operation. I believe that such arguments have to be dismissed, and it should not serve as a justification for the actions of an operator of a drone, simply because we can draw a very clear parallel with those commanders who are making operations with long-range missiles, and they are under the same obligation to assess proportionality. So if such an operation causes excessive damage among civilian objects or injuries among civilian population, disproportionate attack will be again against international humanitarian law. Finally, the attacker is also under obligation to take all feasible precautions to avoid excessive civilian casualties or civilian casualties at all in the ideal scenario. It may be also argued, in my opinion, that when we are dealing with highly technological weapons, such as drones, that can be operated from one country to another, from long distances, we can also raise the threshold for the feasibility and effectiveness of precautions. In fact, when you think about drones, if they are targeting legitimate military objectives, they can also ensure that they are attacking the target when there are no civilians around and when there are civilian objects are not damaged. So the high precision of these attacks should also be taken into account when we talk about precautions. But in many cases, IHL will not be probably even applicable to the situations when the drone attacks are conducted, because usually they are happening outside of the battlefields or within the occupation, where human rights law will be a more relevant framework to analyze. And the very first thing that we need to keep in mind is that the majority opinion is that targeted killings by drones is incompatible with international human rights law. The incompatibility in this case is based on the mere fact that the right to life, the obligations on the right to life, apply extraterritorially, and therefore they prescribe that no one can be deprived of life arbitrarily. The exceptions that are relevant to our discussion would be self-defense and defense of others, as long as the force is used in a strictly necessary and proportionate manner. The drone cannot exercise a self-defense because it's not a human being and the operator is not in danger, while defense of others would probably be unnecessary in a sense that the scale of killing a person would not be needed to protect. And let's also be realistic that the use of drones in this case is never the matter of imminent threat to another person. So these operations are conducted for the different reasons. Even if we presume that such targeted killings could be sometimes conducted in compliance with those exceptions that exist to the right to life, the state that is conducting such operations is also under procedural obligation of the right to life, which is the obligation to investigate any violent deaths. And such investigation has to be impartial, independent, and prompt. When it comes to the extraterritorial investigations and the crimes committed by the use of unmanned weapons, we should all understand that such investigations are very difficult to be conducted, also because we don't always even know who was the operator of such an action. And therefore, the violation of the right to life will appear in the vast majority of the cases. Finally, what is important to keep in mind is that Human Rights Committee in its General Comment 36 had specifically mentioned that both law enforcement officials, including soldiers that are charged with law enforcement missions, are under obligation to take all necessary measures that are intended to prevent deprivation of life of the people who are under their control and under their jurisdiction. And this is the relevant discussion for instance, the cases of occupation. In such situation, there is always a standard of capturing rather than killing. And when we are dealing with a weapon that is there to be targeting particular individuals, drone cannot capture anyone. So it's employed to kill the person, and therefore the standard cannot be respected, and we will inevitably find ourselves in the arbitrary deprivation of life. This whole discussion leads us to the question how to hold accountable the persons who conduct those operations and who is actually accountable for these operations. Well, the problem of accountability in terms of use of drones is basically twofold. From the one side, it's practical because we don't always know who conducting the operation. And on the other side, it's legal because it's difficult to attribute the responsibility. In practice, many operations are conducted by secret services rather than the armed forces of the state. And when they are conducted by secret services, it makes it difficult to identify the operator for the purpose of attribution and criminal responsibility. The other thing is that not all the secret services have necessary training under IHL, and therefore they are not always able to respect necessary rules. Another issue that always raises when it comes to autonomous weapons such as drones is who is responsible for these unlawful acts that are committed with the use of drones. Is it the military commander who deployed the weapon? But then the question is to what extent the weapon is able to act autonomously. Or is it the programmer who wrote the software that had some mistakes that led to killing civilians? Or is it a manufacturer who did not ensure that there are no mistakes and no bugs in the programming and in the functioning of the weapon? All these questions, they are essential from the criminal law perspective when we need to find the person responsible. At the same time, it's relevant to mention here that criminal responsibility of individuals has to be distinguished from the responsibility of states. And the main criterion of distinction is the lack of intent. The state does not have an intent to commit a wrongful act. While individuals, they always need to have the part what lawyers call as mens rea, or the intent to commit a wrongful act. For the state, it's unnecessary. And therefore, the mere fact of deployment of a weapon in violation of the norms of IHL or human rights will lead to the responsibility of the state. And maybe this is the beginning of the discussion when it comes to unlawful use of drones and weapons. If the state is not taking due measures to investigate those actions, that the state has to be held responsible. I thank you very much for your attention.
I thank you, Mrs. Mogutova, for your very interesting presentation that we will publish the transcript of your presentation as usual in a compilation of all the panelist presentations. And I am sure that it will help everybody to better understand this very technical matter. Thank you very much. And now, je vais passer la parole à Maître Mohamed Boula, qui est directeur des études et de la recherche au Conseil national des droits de l'homme algérien. Maître Boula, vous avez la parole. Ouvrez le micro, si jamais. Omeima, Maître Boula est avec nous?
Oui, elle est avec nous. Oui, elle est avec nous.
Est-ce que vous m'écoutez?
Oui.
Oui, très bien.
Le 105 sur 5.
Oui, allez-y.
Allez-y, on vous écoute.
Excellent. Je me présente, M. Boula Mohamed, directeur d'études et de recherche au niveau du Conseil national des droits de l'homme Algérie. Au nom du Conseil national des droits de l'homme, je vous présente mes sincères salutations, notamment aux organisateurs et aux participants. Le thème, je pense, vous avez braqué vos projecteurs sur un thème trop important relatif à l'impact légal de l'utilisation illégale des moyens de technologie modernes par les États généralement et marquer les violations des droits humains. Je pense que mon intervention, elle est répartie selon des axes. Le premier axe, c'est la qualification de la question sahraoui sur le plan des droits de l'homme, puis la qualification de la question sahraoui sur le plan droit humanitaire, la qualification et l'impact, la qualification des technologies modernes et leur qualification comme arme nouvelle qui peut engendrer des effets, des impacts sur les populations vulnérables, notamment au Sahara occidental, puis enfin les responsabilités des actes. Commençons premièrement. Je pense que la question de la Sahara occidentale est une question complexe et compliquée sur le plan du droit international. D'emblée, il faut déterminer la bonne qualification juridique de la question Sahara occidentale. Au premier lieu, et conformément aux principes énoncés dans la Charte des Nations Unies, on doit reconnaître la dignité inhérente à tous les membres de la famille humanitaire, notamment le peuple sahraoui, et leurs droits légaux constituent le fondement de la légalité, la justice et de la paix dans le monde. Je pense que sur ce plan ou sur le plan droit international des droits de l'homme, que l'arsenal juridique international relatif aux droits de l'homme, notamment le pacte international relatif aux droits civils et politiques, qui constitue le corpus international erga omnes, et notamment l'article 1, tous les peuples ont le droit de disposer d'eux-mêmes. En vertu de ce droit, ils déterminent librement leur statut politique et assurent librement leur développement économique, social et culturel. Par conséquent, la question sahraoui, sur le plan droit international des droits de l'homme, on peut la distinguer comme suit. Donc, il y a un occupant, c'est le royaume marocain, et un peuple vulnérable sahraoui occupé. Ce dernier a le droit, selon l'arsenal juridique des droits de l'homme et ses mécanismes, soit les mécanismes internationaux ou régionaux, de demander ou de militer pour avoir un droit irréversible, c'est le droit d'autodétermination. Ça, c'est pour la qualification de la question sahraoui sur le plan droit international des droits de l'homme. Donc, on est devant deux parties. Une partie vulnérable, c'est le peuple sahraoui qui milite pour avoir ce qu'on appelle l'autodétermination indiquée dans les différents instruments internationaux de droits de l'homme, et un pays qui occupe, c'est bien le royaume marocain. Pour la qualification de la question sahraoui sur le plan de droit humanitaire, je pense que les conventions de Genève 1949 et les deux protocoles additionnels aux conventions ont qualifié clairement que les actes commis par le royaume marocain comme conflit armé international. Donc, on est devant la même chose, devant deux parties. Une partie, donc, c'est l'occupant, et l'autre partie, c'est le peuple occupé. Donc, le droit international humanitaire, par le biais des conventions, des quatre conventions de Genève 1949, donc, ont tranché sur la question. Donc, il y a toujours ce qu'on appelle un conflit international armé. Et par conséquent, à mon avis, tous les actes légaux par le peuple sahraoui, soit politiques, soit économiques, donc, elles sont considérées comme lutte et militantisme pour l'autodétermination. Revenons sur la question de l'utilisation des technologies modernes dans les conflits, et notamment le conflit au Sahara occidental. Je vais commencer par un aspect théorique. Je pense que dans la mythologie grecque, le mythe d'Icare, il illustre que le désir de l'être humain d'aller toujours plus loin au risque de heurter aux limites de sa condition. Et je pense que le royaume marocain, il est en train d'utiliser ou d'exploiter ce mythe-là, le mythe d'Icare. Car la première des choses, donc, il occupe le territoire du Sahara occidental, donc les différentes violations qualifiées par le droit international des droits de l'homme et le droit humanitaire comme infraction claire. Donc, sur le plan philosophique ou le plan théorique, il est difficile de déterminer précisément les moyens et les méthodes qui recouvrent exactement l'expression nouvelle technologie qui fait donc l'objet d'un débat passionné impliquant les philosophes, les juristes et les militaires. De même, il est parfait d'avoir une détermination d'une date précise à partir de laquelle on peut dire que cette technologie peut être considérée comme nouvelle. Je pense que le Maroc a utilisé le développement de nouveaux moyens et méthodes de guerre, parce que c'est les conventions de Genève et les protocoles additionnels aux conventions qui déterminent les méthodes, les différentes méthodes de gérer le conflit et la protection des civils, des catégories vulnérables. Donc, il s'agit aussi, dans un cadre juridique, en vertu du droit international humanitaire. Je pense qu'il y a une obligation de la société internationale qu'elle doit vérifier la compatibilité avec le droit international et l'emploi des nouvelles technologies qualifiées comme armes. Dans ce sens, je pense que l'emploi d'une nouvelle arme, de nouveaux moyens ou d'une nouvelle méthode de guerre dès les stades de l'étude, la mise au point, l'acquisition ou l'adoption de nombreux moyens ou méthodes de guerre ont déjà été interdits ou leur usage réglementé au cours de l'histoire. Je cite comme exemple les armes à laser aveuglantes ont ainsi été proscrites en 1995, avant même leur apparition sur le champ de bataille. Et je pense que ce genre d'armes est utilisé par le royaume marocain à l'égard de la population sahraoui. Pour faire une approche entre le cadre philosophique de l'usage des nouvelles technologies dans les conflits, et notamment au Sahara occidental, je dois braquer mes projecteurs sur la question du brouillage de la notion traditionnelle des guerres. Car il est possible, et notamment au Sahara occidental, possible que certaines nouvelles technologies comme les drones de reconnaissance, le sabotage des données électroniques, le piratage des données. Donc, les exemples cités, et notamment l'usage des drones guidés, peuvent engendrer des effets vraiment néfastes. Car ce qu'on a constaté réellement, et on a enregistré réellement, que le royaume marocain a à travers les conventions bilatérales faites avec Israël, bon, il a acheté des drones donc pour but reconnaissance. Donc, s'il reconnaît l'utilisation de ces drones peut engendrer un entrave à l'égard de la lutte du peuple sahraoui. Comment? La première question, le Maroc est un pays occupant. Deuxièmement, l'usage de ces nouvelles technologies considérées comme armes. Premièrement, le drone, il peut utiliser comme outil de reconnaissance. Donc, il peut localiser les civils, il peut localiser des groupes vulnérables, sahraouis vulnérables, et puis, par conséquent, il y a la possibilité de matraquer ou de commettre des infractions qualifiées comme infractions internationales. Donc, elle est considérée comme agression. Donc, les interpellations des civils. Donc, on peut constater que l'utilisation de cette arme-là peut engendrer d'autres infractions. Reconnaître, localiser. Après la localisation, donc l'effet qualifié comme infraction, interpeller, donc déplacer les personnes civiles d'une manière illégale, etc. Bon, les effets entraînés par certaines nouvelles technologies comme l'utilisation des drones, le piratage électronique, le sabotage des données électroniques devraient engendrer une réflexion sur ce que l'on entend par usage de la force armée comme seuil d'application du droit humanitaire, car la règle est une règle jus in bello, notamment dans le contexte d'une cyberattaque. Donc, ça, c'est pour concernant la note. Sur cette question-là, l'utilisation du Royaume marocain des nouvelles technologies qui sont qualifiées comme armes, je pense que le Comité international de la Croix-Rouge a été déterminé à l'égard de cette question. Donc, il a considéré comme si les moyens et les méthodes de la cyberguerre produisent les mêmes effets dans le monde réel que les armes conventionnelles, destruction, dégâts, dommages, blessés, morts, torture morale, ils doivent être gouvernés par les mêmes règles que les armes conventionnelles. Je pense que la qualification est faite par le CICR, par le droit humanitaire, malgré le manque dans l'arsenal juridique international. Sur le plan de justice et responsabilité, on peut distinguer la justice internationale ou la responsabilité internationale des États. Et donc, on peut auditionner le Royaume marocain, car la Cour internationale de justice a insisté sur l'importance de cette clause, l'utilisation des nouvelles technologies qui est qualifiée comme arme dans le cadre de son avis consultatif sur la licéité de la menace ou de l'emploi d'armes nucléaires. C'est dans le même sens. On peut aller plus loin dans le cadre de la responsabilité, là où les circonstances peuvent être disponibles. La compétence de la Cour pénale internationale, donc régie par le statut de Rome 1998, qui a qualifié les 4 infractions internationales. Donc, il y a l'agression, les crimes de guerre, les crimes contre l'humanité et le génocide. Je pense que l'utilisation des nouvelles technologies comme armes peut formuler l'élément matériel de chaque infraction citée. Donc, dans le cadre prochainement, après le constat, le rassemblement des documents, etc. Donc, là où la possibilité permettra, je pense que l'utilisation illicite des moyens technologiques par le Royaume-Uni qui provoque d'autres infractions vis-à-vis la population vulnérable sahraoui peut engendrer une poursuite pénale internationale, sans oublier les mécanismes quotidiens ou permanents, les mécanismes permanents devant le conventionnel, c'est les conventions, les instruments internationaux des droits de l'homme, c'est les comités des droits de l'homme, là où on présente des rapports parallèles, etc., là où on peut évoquer ça. Je note aussi que le rôle du CICR ou du Comité international de la Croix-Rouge doit être efficace pour la qualification et la notation. Je vous remercie.
C'est moi qui vous remercie, Maître Boula, pour votre présentation très détaillée et pour votre rappel aux normes du droit international. Et je vous précise que votre présentation aussi fera l'objet d'une publication. And now I welcome Professor Zunes. Good morning, Professor. Professor Zunes is in San Francisco. He's 9-hour difference with us, so it's something like 7 o'clock, 7:30 now in the morning. So welcome, Professor Zunes. I will give you the floor, I will introduce you. So Professor Zunes has been at the University of San Francisco since 1995, teaching courses on the politics of the Middle East and other regions, nonviolence, conflict resolutions, US foreign policy, and globalization. He served as the founder and first director of the Middle Eastern Studies Program. A prominent specialist on US Middle East policy, Professor Zunes has presented hundreds of public lectures and conferences papers in both the United States and over a dozen foreign countries. He has traveled frequently to the Middle East and other conflict regions, meeting with prominent government officials, scholars, and dissidents. He has published hundreds of articles in academic journals, anthologies, magazines, and elsewhere on such topics as US foreign policy, Middle Eastern politics, Latin American politics, African politics, human rights, arms control, social movements, and nonviolent action. He has served as a writer and senior analyst for Foreign Policy in Focus and associate editor for Peace Review and a contributing editor of Tikkun. Professor Zunes, you have the floor.
Thank you very much. With this group, there is not a lot I can add in terms of the situation in Western Sahara and the significance of the struggle of the Sahrawi people for their freedom and their right to self-determination. What I would like to observe, however, is that the tragic Russian invasion of Ukraine can perhaps provide an opening where we can advance the cause in the media, in academic circles, among international non-governmental organizations, and hopefully among our governments as well. I was struck, of course, by the strong categorical statements that we have seen, for example, in the G7 summit in Scotland a couple of months ago, where the leaders of the advanced industrialized democracies described how that no country can expand its borders by force. Indeed, we have seen leaders throughout the world emphasize how international boundaries cannot be changed unilaterally. That aggression must be stopped. And indeed, it's been very moving to see throughout the world how people have responded to Russian aggression. Everything from the Ukrainian flags and social media, and the calls for boycotts and sanctions and other means of pressuring the Russian government to end their aggression. The world has been very clear that just because a country may claim some dubious historical ties to another people's nation, that does not give them the right to forcibly take it over. Now, the parallels with Western Sahara, of course, are very striking here. And this is something that can be to our benefit. I have written a couple of short articles, op-eds in newspapers and online forums, which have gotten much circulation that would not have otherwise taken place. I mean, usually, as we know, particularly here in the United States, Western Sahara is largely ignored. Most people have never heard of it, even those who are generally concerned about the Palestinian struggle and other struggles around the world. But by making the hook into the situation in Ukraine, people are interested. The second edition of my book, the revised, expanded paperback version of the book I wrote with Jacob Mundy, entitled Western Sahara, War, Nationalism, and Conflict Irresolution. I actually hired a publicist to try to get me interviewed on radio talk shows and elsewhere. And even with a professional publicist, I was having trouble getting interviews. But when we started connecting with making the linkage with Western Sahara, pointing out the hypocrisy and the double standards that the United States and other countries have, there was interest. People really were able to recognize that the support of Morocco by the United States, by France, by other countries is directly counter to the message that the Western democracies are trying to send to the world about how wrong Russian aggression against Ukraine is. And as a result, I do see this as a potential opening, that the narrative that we are hearing, that the foundations of international law are being tested by Russia, and the need for the international community to have a very firm and unified response. This is very important, and we should support that. But we should also point out that this has been going on in Western Sahara for over 46 years, and that this is totally unacceptable. That if we really believe in that countries must not engage in these kinds of acts of aggression, that countries cannot expand their borders by force, that countries cannot unilaterally change international boundaries, that countries can deny the right of people for self-determination. If we really believe that, we need to support freedom for Western Sahara, not just for the people of Western Sahara, but for the world. Because if Morocco can get away, the line we're hearing about the Ukraine, of course, is that if Russia can get away with a takeover of Ukraine, that it will embolden aggression everywhere, that it's not just about Ukraine, it's about international peace and stability. And this is the message we need to give about Western Sahara. I would support freedom for Western Sahara simply for the people of Western Sahara, because I love the people of Western Sahara. The Sahrawis deserve their freedom in their own right. But I am also concerned about this because I am concerned about the international legal order. And so this, and I believe that in pointing out these double standards about hypocrisy, we can say, as I have said, and repeatedly in recent weeks, that the cause of the international community to challenge Russian aggression is hampered severely if we support Moroccan aggression. Because the Russians and their apologists can simply say, oh, you don't really believe in the principles you say, because look at what you're doing with Morocco and Western Sahara. You're only doing this because you're anti-Russian. You're only doing it for your geopolitical interest, not out of principle. So if we can convince the international community to take a firm stance against Moroccan aggression, to say that the people of Western Sahara also have the right of self-determination, that like Russia, Morocco cannot expand its borders by force. The international community will not just be doing the right thing for the people of Western Sahara, we will be stronger in challenging Russia and other potential aggressors, because it will show the world that we actually care about these principles and we aren't just making this an issue for geopolitical reasons. So as tragic and terrible as what the people of Ukraine are experiencing right now, I hope we can use this crisis as an opportunity to further awareness of Western Sahara, to gain support. Indeed, the Chinese character for crisis is a compound word for danger and opportunity. And this is what we're experiencing right now. And I hope we can take advantage of this in ways that will support the freedom of all people from aggression, whether they be Ukrainians, Palestinians, Sahrawis, or anybody else.
I thank you, Professor Zunes, for focusing on this very important issue, double standards in applying international law, which is of serious concern for the application of international law, and in particular international humanitarian law and human rights law. Thank you very much, and of course for your participation at a very early time for you in San Francisco. And now I will give the floor to Mr. Majoub Mlehla, who is member of the Western Sahara Collective of Human Rights Defenders. Majoub, you have the floor.
Thank you, Gianfranco. Thank you, everyone. I hope the voice is clear. Thank you very much for this initiative, indeed, and a very important and interesting topic that every one of you have touched it from its angle. My name is Mahjoub Maliha. I'm a human rights defender from the occupied territories of Western Sahara, based in Belgium. Active with the collective of Sahrawi human rights defenders in Western Sahara, known as CODESA. Also active on different topics such as the natural resources with Western Sahara Resource Watch, and conducting different advocacy civil society activities on both EU and UN level. Well, my case, I'm here just to testify on being targeted by the Pegasus spyware, the Israeli NSO developed software. How I found it first, last year in October, attended the fourth committee session in New York and conducted a couple of advocacy meetings in DC. After coming back from the United States on the 1st November, I received an email exchange that I had with the State Department. Just a regular reply on human rights report, but I noticed that someone have read the message or the email before I could even open it. That was suspicious. I had suspicious or suspicions before that I may be targeted, but then we always underestimate the work we are doing, considering the high cost of such a software, and you just don't think it will be one of the priorities the Moroccans would put on the list. So once I noticed that the email was read before me, I contacted Amnesty International and technical lab, shared the system diagnose and backup of my device, and 2 hours later was confirmed that my phone was under surveillance at least since January 2021. Being a regular human rights defender, a civil society member with no major political agenda or even political responsibilities, you don't really expect it. But then when you realize that you have been targeted with Pegasus, the first thing you do is try to find out what this software can do. Of course, we all heard about the story which was broken back by Forbidden Stories. We read here and there articles about it, but then when you dig in it, you find out that this software have full access to your entire life, to your network, to the people you love, to the people you work with, access to your bathroom, to your toilet, to your bedroom, to your everything. So access to your location continuously. They can monitor you, listen to you, record you all the time. And this data, this massive personal data, are in hands of hostile entities who use it necessarily to harm you, not to protect you. So when you realize that, it's kind of a shock to any one of us. You just can imagine for a second that someone is recording you while taking shower or recording you while sleeping. And then you will start freaking out on how much data or information those people have already taken against your will. Why have been targeted? I think because of the activities they do for the human rights, for protecting human rights in Western Sahara, defending the principle, the very principle right to self-determination that our people have, and defending the cause of the Sahara people to be free. Maybe some more presence on the media, playing coordination roles in specific or certain actions. The visits conducted to different political actors could be another reason to put you on a list of targeted people. So as I said, when you realize that such a massive quantity of personal information are in wrong hands, then you start to get, I'm not sure to describe it as getting scared, but to get annoyed, definitely, knowing that people with intention to harm you are having access to your entire life, entire private life. It does not such an act, an illegal and unethical act, to hack into a personal phone, doesn't only put me as a person in danger, but put all the people I am working with, or people I know, or people I interact with are also in danger. I realized that back in May, when my colleague Bouzaid Mohammed Saeed and two other colleagues from Kodesa were with Sultana preparing and we were coordinating how to visualize the campaign with Sultana. Suddenly, one early morning, the Moroccan occupying forces streamed into the house of Sultana Khaya and her family, kidnapped the three colleagues, tortured them, dropped them outside the city, about 60, 70 kilometers south of the occupied Layun. Many other acts, many other actions maybe have been taken to prevent or to harm other human rights defenders or others of my colleagues. What make it more serious is when you look at cases, similar cases that Morocco has used this software against them. For instance, Ma'ti Munjib, Omar Radi, Slimar Resuni, Bouashrin Tawfiq, those are journalists who ended up in jail with long sentences, with fake legal actions or fake cases. If you think about Khashoggi, who ended up dead, so you start really thinking about the real danger you are into, with people can reach you in any moment. Maybe those companies who develop such softwares claim to use it against terrorism and drugs cartels. Of course, we do agree indeed that there are security challenges, but there is definitely no justification for using such programs against human rights defenders. I don't really see anyone who can explain it. And NSO tried first. Of course, we know that Morocco have denied using Pegasus software firsthand, and even tried to sue some of the international journalists who have published stories about that. And later on was confirmed by both NSO and Israeli officials that Morocco is one of the customers using Pegasus from NSO. So in that way, NSO is not only responsible for putting people in danger, or not only responsible for the misuse of such technologies, but also responsible for covering up the bad acting and the misuse their clients conduct to allow their impunity. On the other hand, such technology, or such the case of Pegasus, of course, it is without cure. Experts advise you to change your mobile phone, but at the same time they tell you they can hack into it the next moment you get a new phone. So it's not really a solution, and the gravity of the Pegasus case and the increase of number of misuse from different undemocratic regimes and even occupiers is actually a motivation to the international community and the civil society to raise and fight against the use of such sophisticated programs or spywares. It is also a sign it is also a sign that the legislature around the world have to look at the entire industry of surveillance technologies. There is a lack of solid regulation for surveillance technologies trade. We have, as it is a crime that have no borders, it should be regulated on international level and put in place comprehensive legal regulations and code of conduct that prevent regimes that have at least to prevent the regimes that have no human rights safeguard from accessing or acquiring such technologies. We need to have an introduction of global regulation to prevent such companies from obtaining the necessary infrastructure, as NSO, for instance, that has proven to misuse the technology it has. We need a comprehensive investigation on each government or country that have been proved to misuse such technology against innocent civilians. There are also sanctions to be applied, whether on the US Global Magnitsky Human Rights Accountability Act or the European Human Rights Sanction regulations. Those indeed are areas of development and work. The regulations and the law is quite not clear on such unethical and illegal activities that all legislators around the world should have a look on it. It is claimed to be a necessary technology to save people's lives from terrorism or global drugs cartels. But it is very necessary to have such weapons in the right hands, not irresponsible regimes or irresponsible companies can develop and use such programs against human rights defenders or innocent people. It is very difficult for many countries or many people around the world to imagine that there are regimes ready to sacrifice their innocent people, present them to the West as terrorists in order to access your military, political, and financial support. Well, that exists, and you can find the very example in Morocco. So I try to make it short. This is my experience indeed with being spied on using the Pegasus software. Proceedings on the legal part are still unclear, but there will be definitely a legal path to follow toward justice on accessing personal details, personal life against the people's will. And I thank you very much.
I thank you, Majub, for your testimony and also for your analysis on the matter. And now I think Hamdi Salek is with us, and I hope that his micro will function. Please, Hamdi, you have the floor.
Hi. Good afternoon. Can you hear me? Good afternoon.
Yes, please.
Yes. Well, my name is Hamdi Salek. Thank you for inviting me to speak on behalf of my organization, which is the Sahrawi Association of Landmine Victims. First of all, I would like to recall that Morocco has carried out a war of extermination against the Sahrawi people since the beginning of its invasion and occupation of Western Sahara in 1975. Morocco used everything in its disposal to kill the defenseless Sahrawis from air and on land. Morocco built the longest defensive wall in the world, protected with millions of landmines. As a result, Western Sahara is now one of the most contaminated areas with mines in the world. My organization is concerned with the victims of mines in Western Sahara due to the Moroccan war against the Sahrawi people. My organization has since its foundation counted tens of hundreds of victims of Moroccan mines in Western Sahara, hundreds of survivors, as well as hundreds of dead victims. The point that I want to underline here is that since its violation of the ceasefire on the 13th of November 2020, Morocco has used new dangerous policy and has used a dangerous new technologies to carry out its policy of extermination and killing of the defenseless Sahrawi civilians in the liberated territories of Western Sahara. In particularly, the use of unmanned aeroplanes. And here we would like to condemn this new Moroccan extermination policy against the Sahrawi civilians in the liberated territories of Western Sahara, and call on the international community to intervene and to protect the Sahrawi people and prevent Morocco from continuing this policy of extermination against the defenseless Sahrawi civilians in Western Sahara. And thank you.
I thank you, MD, for your testimony. And now, last but not least, I will give the floor to His Excellency Mr. Hubi Boushaya, Minister for Europe of the Sahrawi Arab Democratic Republic. Hubi, you have the floor.
Okay, good afternoon, everybody. Thank you very much, Gianfranco. First of all, I would like, on behalf of the SADR, the government of the Sahrawi Republic, but also that of the Frente Polisario, to extend our thanks to the joint organizers of this important event, the Geneva Diplomatic Group of Ambassadors and the group of NGOs led by the South African ambassador and Gianfranco, respectively. The use of modern technologies and the violation of international humanitarian law and the human rights in Western Sahara, it is a timely initiative to place this very important issue on the radars of the Council of Human Rights in its current session, and also to a certain extent to the international public opinion at large. As you know, international credible and impartial reports elaborated by different organizations and consortiums such as Forbidden Stories have proved Morocco being behind a systematic use of the malicious software Pegasus to spy on many people across the globe, not only in Western Sahara or the neighboring countries, but across the globe. Personally, as member of the Frente Polisario leadership, I have been identified by the consortium of over 20 media houses in collaboration with the Amnesty International as part of the list of people who have been repeatedly being spied by the use of this Pegasus. In this regard, and because of the constraints of time at this stage, I would like to just concentrate on two short remarks around this story. One, long before I have been contacted by the consortium, I knew that I would be a potential target of any Moroccan project in this regard. I wasn't surprised when they analyzed my phone and they confirmed the existence of the spyware and the different and continuous interventions in this regard. Prior to the whole story, many of the Sahrawi leaders and diplomats have noticed that some of our communications have been intervened, especially with some prominent foreign activists and Moroccan opposition members, among others, of course. As indicated earlier on by Claude Mangeon, four of us, Claude, the mayor of Ivry-sur-Seine, and our lawyer, Joseph Breham, and myself, we have introduced a complaint in Paris against this act. And the procedure is well engaged. Claude is not aware, but I met with the investigators last Monday, and we are very hopeful that the court will establish the truth about this story. Of course, it's not about me personally. It's not about Claude either, but it's mostly about the people of Western Sahara and the human rights and the rights of people to privacy ultimately. This act is an additional proof of the fact that Morocco is embarking on unprecedented campaign of human rights violations against the Sahrawis, that this time around goes even beyond the open sky prison of the occupied territories to go and spy and intimidate the Sahrawis outside and their friends. The second remark is in relation with the Morocco has been clearly identified as the country who was largely behind the most important volume of interventions using the spyware Pegasus. Yet, and despite the media storm that followed the reports, practically nothing has been done so far to force Morocco to respond to its acts. The Moroccan impunity is still the norm, and now it's no longer only the Sahrawis who are the victims of the Moroccan violations, but presumably also many European citizens. It is high time for the international community, especially the UN Human Rights Council, to draw the necessary attention to this widespread criminal use of the spywares and the sophisticated equipment against the civilians. We hope that these initiatives will be followed by others that will pave the way to get tangible results in this regard. I thank you for your kind attention.
I thank you for your remarks and the information you shared with us. And yes, indeed, the Human Rights Council as agendaed already further discussion on these issues for this year and next year. And with this, we run out of time, but I don't know if anyone would like to raise a question or make a remark before we close the session. Just raise your hand if you want to make any comment. So if this is not the case, I would like to thank you, everybody, for your participation in this conference. Of course, the panelists, thank you very much. And Professor Zunes has left because he's going to participate to a manifestation. And excellencies, dear colleagues, and ladies and gentlemen, thank you very much for your participation. And we will publish all the intervention in 3 languages, English, French, and Spanish, and it will be published and distributed very soon. Thank you very much to all of you.
Thank you very much.
Thank you. Goodbye.
Thank you all. Bye.
Bye.
See.